is coming under the compelling circumstances. No normal circumstances.
Well, otherwise I would not have troubled your lordship on this side of the vacation.
Yes.
Well, in fact, your lordship was pleased to take up this matter yesterday. Mr. Sen was on the other side because your lordship said that the interim order has been once again extended, gave us leave to file a fresh memo, which was done. Well, today the indication of your lordship's list is that the order 41 will be taken up from item number 44. So well, this is item number 33 and 34. So even if his order 41 is taken
we are
up,
taking up applications.
thereafter your lordship will take up order 41
Don't worry. Let us. There are
from item 44.
Come on Monday. There are huge applications. Don't
So
worry.
what I am not on that, my lord. Kindly, because if this indication will remain in the list, it will be from item number 44.
So
which is,
the other matter would be listed there. No difficulty.
yeah,
don't worry,
indication
we'll
is
take
from SAT 96. So if it is 96, then mine is before that.
No, after that, there is another appeal which you have filed. Don't worry, which you have filed yesterday.
Yes, well, that has got, that's a memo of appeal.
Correct.
Item number
So we will-
36. That's all
correct.
together. So they are all before. That's what I'm saying.
We'll
34, 33, 34, 35, and 30.
Yes, yes, we know it. We'll
33.
consider that. Don't worry.
My lord,
Yes.
very urgent, my lord.
Very urgent.
Application, my lord. 235.
Application we will be taking up. Just permit us
My lord,
to
your lordship,
start.
1 minute. 169, your lordship from 169 called on. My lord, today. Mine is, my lord, 235. If not reached, my lord, your lordship kindly take it up at 1 p.m. My lord. No caveat. It's a partial partition, my lord. Dismiss, suit dismiss, and it's covered by your lordship's unreported judgment. Lordship kindly.
My lord,
Give order 41, all applications
may I
get.
pray for your lordship's kind leave to mention a matter? My lord, we had moved the matter on Monday. Your lordship was pleased to allow the section 5 application and directed the matter to appear on Wednesday.
41.
Under order 41 rule 11 heading. My lord, our learned advocate on record received an SMS that the matter would be listed today, my lord, on 13th. My lord, the order was uploaded yesterday, my lord. My lord, it shows that the matter was returnable on the 11th, but my lord, it is also not appearing in the list today.
It will
My
appear
lord,
in
there
the
is some urgency, my lord.
list. It will appear in the list.
My lord, we
Hey,
kindly-
can you hold on? Huh? Achha.
My lord, company purchased land by way of a
Whatever,
postal.
sir.
My lord, kindly
Your
direct.
advocate and record has said something else.
No.
What can be done, sir? Anyhow, give the slip.
Your lordship, my advocate. Lordship.
My lord, may I be permitted to mention urgent application, my lord? A matter is appearing under the heading application 156. The special notice or matter will be taken up 169, my lord. There is some.
You ask for an adjournment.
No, my lord. Today is the returnable date. 13th is the returnable. No, it was.
No, that is what we say, but we will go. If you have asked for an adjournment, then the others who are waiting in the queue, they must get an opportunity. Every day you ask for an
No,
adjournment
my lord.
and get a precedence.
I
That
have
will not.
not prayed for as well.
Anyhow, sorry.
There is some urgency, my lord.
There's maybe we'll consider. We will dispose of the whole of this. Don't worry. Whole week we will take it up.
My lord, at my instance, non-prosecution,
Non-prosecution.
instruction of my client.
Yes, show us. Are you paying the maintenance? Are you paying the maintenance?
I am for the appellant, I am for the wife, my lord.
What? Wife is the appellant.
Yes,
I am asked. Oh, sorry. The respondent is paying.
yes.
Paying.
Now it has been stopped.
And you want to withdraw.
Withdrawn,
It has stopped, but you want to withdraw.
my lord, because I have some other instructions. She doesn't like to proceed with the matter any further.
Yes, Lako. The advocate, you are the advocate on record?
Yes, my lord.
What is your good name, sir?
Samir Kumar Chakraborty.
Yes. The advocate and record of the applicant submits on instruction received from his client that his client is not interested in proceeding with the instant appeal. Stop. A written instruction received by him and filed in court today be kept on record. In view of the above, the appeal is dismissed for non-prosecution.
Only my lord,
The connected applications are accordingly dismissed. Interim order, if there be any, stands vacated.
only my lord, original my lord, judgment and decree my lord be take back my lord, please. Right? Otherwise, my lord, from past,
You apply. Lower court record has come. It has not come. You file it, you obtain it from there. Yes. Call the next.
The respondent.
My lord, I am appearing on behalf of the appellant.
What is the report? তিনটে কপি দেওয়া হয় একটা সেন্ট্রাল ফাইলিং ডিসপ্যাচ সেকশনে থাকে দুটো কপি ডিপোজিটরকে দিয়ে দেওয়া হয় টু ফাইল ওয়ান উইথ দি এফএ সেকশন এফএ সেকশনে গিয়ে জমা করে such non-availability of the receipt happened is to ask for the report. But the central filing section to করবে flag B. Okay. Hey, where is flag B? Again. You too?
Who is your place?
Ago, pursuant to the order. Dated 10th of October 2023, the dealing assistant and the section officer of Central Dispatch Section has submitted the explanation. It is indicated by the dealing assistant that the register maintained under the old system manually invites a human error to occur because of the use work pressure and therefore could not, and therefore due to inadvertence, the wrong report was put on the file. The section officer forwarded such explanation with the rider that the said dealing assistant has been removed from the specified table dealing with the messenger costs mere removal of a dealing officer, dealing assistant from discharging such duty is not acceptable as a corrective measures are required to be done in this regard. Everybody is grappling with the menace of the heap of pendency of the matters in the docket of the court, which does not mean that it would augment the human error, and the proper care and vigilance is not required. We appreciate that human are prone to committing error, either in life or in professional career. Yet, the same cannot exonerate a person from discharging an onerous duty cast upon him. While putting a note on the file, the officer must be careful in making a note, obviously based upon the record, and it appears to us that there is a complete carelessness on the part of the dealing assistant. Furthermore, the court directed the appellant to deposit the special messenger costs in order to expedite the lower court record to be brought before this court, so that the appeal can be made ready and disposed of as expeditiously as possible. Such a dereliction on the part of the dealing assistant appears to us being one of the factors relating to explosion relating to docket explosions. Unnecessarily, the matters are kept pending, as the procedures have not been completed as contemplated under the Code of Civil Procedure as well as the appellate side rules, which have a statutory flavor. We expect that all the officers and the employees of the High Court should be sensitized in this regard, and the recurrence of such carelessness should be avoided. Be that as it may, we do not intend to go any further, nor to take any steps against the dealing assistant. Yet, we record the note of caution that in future they would be more careful, as the court believes the note put on the file by such officers as sacrosanct. Next, since the special messenger cost had already been put in, the FA section is directed to take immediate steps for bringing the lower court record and shall ensure that the same reaches to this court within 1 week after the reopening of this court following the Puja vacation.
Kindly after 2 weeks, praying for 2 weeks.
Oh, you are saying this is on the department. How can you interfere? Your interference with the department is the real cause. Why you will go in the department?
Wrongly.
After the arrival of the lower court record, the office shall immediately examine the same. And if found complete, shall put a note in this regard and serve a notice, is the first appeal, serve a notice under Rule 12 of Chapter 9 of the Appellate Side Rules on the learned advocate on record of the appellant. The appellant shall prepare 8 copies of informal paper book, cyclostyled, printed, typed, photocopied, within 4 weeks from the date of the service of notice of arrival or record, and shall file the same in the department. After filing of the paper book, liberty is granted to the parties to pray for listing of the appeal before the appropriate bench. Yes.
I beg to appear on behalf of the appellant father, my lord.
I am for the mother.
Yes.
I am for the appellant, my lord. My lord, this is the custody matter, my lord. Live streaming. This is that matter where
I understand. Both are present.
Yes, ma'am.
If this report comes, why both of them sit together and resolve for the sake of the child, for his life? Can't they revisit what has happened in their life for the sake of a child? Can't they think of the psychologists who are well-known psychologists in the city? 4 of them, they have opined. If you do not care your child, then why you have brought them into this world? Why you brought them into this world? The report says that whatever is, there is a very, very significant changes which is coming in his behavior and in his, the mind because of this conflict between the father and the mother. Can't you think for the sake of a child? You may have your right, you may think, but think about the child when you have brought them in this world. If the child continued to undergo in this way, the development shall be impeded. Why don't you, I think, assert your office, good office, and let them sit together and the resolve for the sake of a child.
We will take.
My lord, my client is ready and willing.
Why your client is not interested?
My lord, there is no question of interest, my lord. I have discussed with my learned friend.
What do you think of all the psychologists have said about the children, about this child, and says that he's a wonderful child, very matured.
May I submit, my lord? There was no issue till December 2022.
I tell you very frankly, in my life and the experience which I gained, when you sit across the table, after there is some conflict,
with whom he got acquainted in his workplace. My lord, he used to repair his bike. He used to wash his bikes and all. My lord, from there he came in contact with.
how Rustam Singh is related to the parties.
রুস্তম শেখ নমিতানার সাথে কিভাবে রিলেটেড?
ওটা আমি জানি না। ও আমাকে বলেছিল যে আমার পরিচিত একজন, আমার মানে বাড়ির কাছাকাছি থাকে একজন পরিচিত ভদ্রমহিলা, বয়স্ক লোক, খুবই ভালো লোক। ওর সঙ্গে হয়তো রিলেশন ভালো, এবার আমি জানি না সেটা। আমার সঙ্গে পার্সোনালি জাস্ট দুবার ওর দেখা হয়েছিল। ও একবার নিয়ে এসছে, মানে দেখা হয়েছিল, জাস্ট ওই দুবারই বোধহয় দেখেছিলাম, তারপরে দেখি ওই জিনিসটা ইয়ে।
Ma'am, my lord, he is saying that Rustam Sheikh is the petitioner, the plaintiff in this trial court below, who is his neighbor. He got acquainted with her, and thereafter he informed him to see what can be done. My lord, that's how what he is saying, my lord.
He personally does not know the plaintiff.
Personally, চেনেন plaintiff কে?
আমার পার্সোনালি আমার সঙ্গে কোনো সেরকম রিলেশন নেই, আমি জাস্ট ওই একবার জাস্ট দুবারই হয়েছে, মানে দেখা হয়েছিল, দেখেছি ভদ্রমহিলা বয়স্ক লোক, এইটুকুই আর কি।
He met her twice, my lord.
Why so much of confidence being reposed on him by a person who is not known to you?
আপনার উপর বিশ্বাস কেন করলো? যাকে আপনি চিনেন না, আপনাকে পাওয়ার দিয়ে দিল কেন?
হ্যাঁ, ব্যাপারটা আমি যেটুকু জানি ছিল যে ও যাওয়া আসা করতে পারবে না, পাওয়ারের ব্যাপারে আমার এক্সাক্ট পুরো নলেজ তো তখন ছিল না। বললো কোর্টে তুই যাওয়া আসা উনি করতে পারবেন না।
We don't have any knowledge about power of attorney.
আমি
বলুন।
হ্যাঁ, তো আমি যখন
I do not want you. You have a lawyer.
বলুন।
কি বলুন?
আমি
দর্শক জিজ্ঞেস করলে তোমার না পরিচিত তোমার বিশ্বাস করে পাওয়ার।
রুস্তামের সঙ্গে তো আমার অ্যাকচুয়ালি আমি যেখানে কারখানায় কাজ করি, তো ওর সঙ্গে প্রায় 10-11 মাস, প্রায় বছর খানিক আমার সঙ্গে ওর মানে এমনি পরিচয়। ও আমরা একসঙ্গে একই জায়গায় কাজ করি, কারখানার মধ্যে ও কাজ করে, আমি অ্যাকাউন্টসে কাজ করি। তো দু একবার বাইক ফাইকও আমার সারিয়েছিল। তো এইভাবে ওর সঙ্গে জাস্ট ভালো একটা মানে এমনি পরিচয়, যে এক জায়গায় কাজ করি বলে। তো ও বলেছিল যে তোকে, মানে উনি যেহেতু যাওয়া আসা করতে পারবে না, তুই কি জাস্ট দু একবার যদি যেতে হয় তো ওনার হয়ে যেতে পারবে? ভদ্রমহিলা ঠিক আছে, আমি তাহলে যাবো, একবার দুবার যেতে আসতে অসুবিধা নেই, বেশ। বললো ঠিক আছে।
রুস্তম কে?
রুস্তাম আমাদের কারখানায় কাজ করে।
মানে he works in a
হ্যাঁ, মানে কারখানা।
wooden furniture making factory. There, আপনি কি হিসাবে?
আমি ওখানে অ্যাকাউন্টস, মানে
There he works as in the accounts department. আর ওখানে রুস্তম কাজ করে।
রুস্তামও কাজ করে। ও অ্যাকচুয়ালি ওই মানে কাঠের কাজ বাজ করে, মানে
ও কোন অঞ্চলে, কোথাকার থাকে?
ও থাকে সে ক্যানিং এর থেকেই ওর বাড়ি।
কি নাম?
রুস্তাম শেখ।
Rustam Sheikh also works in that factory, sometimes polishing furniture and all. So Rustam had requested, he said to your junior that he was a mechanic of a bike. He used to repair his bike
করে ও বাইকের
and then how
আমার দু একবার বাইকও আমার সারিয়ে দিয়েছে।
he also knows tidbits of motorbike. So sometimes he helps him in his bike repairing.
he is so public spirited person that he will do a pro bono job for anybody else, filing a suit in the court, does not know the principal and acting as a agent.
একজনের কথাতে আপনি পাওয়ার অফ অ্যাটর্নিতে সাইন করতে রাজি হয়ে গেলেন?
দেখুন আমার এই বিষয়ে টোটাল যে মানে ও যেটা বলেছিল যেটুকু আমাকে, আমি ওনাকে ক্লিয়ারলি ওটাই বললাম যে উনি বয়স্ক, উনি বারবার যাওয়া আসা করতে পারবেন না। তুই কি ওনার হয়ে জাস্ট দু একবার যদি মাসে একবার দুবার যদি যেতে হয় ওনার হয়ে শুধু কোর্টে যাবে, তুই তো কিছু করছিস না। কেস তো ওনার ব্যাপারে, ওনার গড়িয়ার ওখানে ওনার বাবার সম্পত্তি আছে, তো ওই নিয়ে কিছু কেস কামারি আছে। তোকে যদি কোর্টে দু একবার যদি ওনার হয়ে যদি যেতে হয় কাগজপত্র নিয়ে, তো তুই কি, আমি বললাম যে তাহলে আমি দেখি একবার। ও নিয়ে এসেছিল তার বারুইপুরে একবার ওনাকে, তো আমি দেখলাম হ্যাঁ শুধু বয়স্ক মহিলা, তো একবার আমি ঠিক আছে যদি যেতে হয়, আমি কিন্তু বেশি পারবো না, তো ঠিক আছে তোকে কিছু চিন্তা ভাবনা করতে হবে না, তুই জাস্ট মানে যদি যেতে হয় কোনো সময় তুই যাস।
Just a volunteer, he volunteered on the basis of Rustam. Young age, does not know the implication. What happens if anything goes wrong? No understanding of, that's after listening.
Lawyer, he approached the lawyer, he provided all the facts to the lawyer drafted the petition.
That perhaps.
He verified the statements, everything he did it.
Well, whatever
He's
we,
taking care of the lawyers as well. Only on the version or the request of somebody else. Is it so simple and a believable story?
my lord knows that in the affidavit portion, whatever we put in, usually.
No. It is always a paramount, I mean, the most important duty of the lawyer when he drafts every paragraph, he has to say whether you know it or you do not know it. Then how you are saying this? Then the verification comes true to my knowledge. Then the information derived from the record or a document which I believe to be true. Everything comes from there.
The lawyer
Everything is true to the knowledge of a constituted attorney.
last time lawyer said he received the papers from this person. The client also said, kindly see last order recording.
এই যে এভিডেভিটের পাতায় যে লেখাগুলো হয়, এর একটা এর একটা গুরুত্বপূর্ণ ইয়ে আছে। হ্যাঁ, এই প্যারাগ্রাফ কোনটা কি, এগুলো আপনি কি বুঝে শুনে
We are sending the matter to the criminal court. Let the investigation be done. If Rustam Sheikh is there, he will be called as the police will make an investigation. Everything would be done.
Only I will be saying
As-
because there are something behind back. Don't dispose of this matter. I will say, my lord, other because on the first day I submitted before your lordship 2 judgments where the apex court, my lord, the Honorable High Court has not taken any step. Apex court, my lord, keep the matter pending, and my lord directed the investigating agency to submit a report. Kindly see your lordship's order. The judgment I have submitted on 13 September 2023. Now, my lord, another thing, my lord, I suffered a loss because for more than 1.5 months they obtained the injunction order. Now, one person is coming, I don't know anything. Another person,
তো ভুল হয়েছে।
there are something behind back. I'm telling you, lordship.
এটা তো আমি সত্যি বলতে জানি, জেনে বুঝে কেউ এই কাজ কে আর করবে।
And surprisingly, the Panchayat authority saying that they used to issue the death certificate after 1992. I have also annexed my supplementary affidavit.
He will divulge the truth before the police. Let him. Because from the documents which are produced before us, it appears that this document is absolutely a forged document. And if it is a forged document, everybody, even a lady, the plaintiff, there appears to be a doubt of her existence. Though she came, it appears if the gentleman has died in 1964, how can he give birth to a girl child in 1970?
64 সালে মারা গেছে তার বাবা, 70 সালে জন্ম হচ্ছে।
So everybody, if it is there, everybody has to go behind the bar.
He's
No, not so innocent. Is not so innocent, sir. It's very easy to file a suit on these grounds and then everything comes. At least we do not know, at least this matter where the documents have come. There may be many matters where nothing has come out.
And that's the observation of the apex court, that the court is not taking any steps, and that's why these person are indulging.
We will not spare. Once the document forms part of the record, we will not spare. Will not spare anybody.
No, I leave it to you, Lords.
He has to go. He has to go. Otherwise, he has to disclose everything before the investigating officer.
ও কি করবে? ওকে ওকে নিয়ে ধরে আসবে।
একদম বাজে বকিস না, যা জানিস না চুপ করে থাক। জানিস না।
There is one judgment of the Supreme Court long back of the then CJI Justice Balakrishnan. I think this similar incident happened, and then the order was passed, the registration of an FIR and all these criminal proceedings to be initiated. That is a reported judgment.
I found two reported judgments. Madam, if you actually see once, my lord, the order passed by your lordship on 13th, because your lordship has recorded in the order sheet, 13
No, no,
September
you have relied upon Badami versus Bhali.
one jai Badami versus Dhali one.
Ah.
Another one I have given, my lord, if you lordship see, but that is Ramrareshwari Devi and others versus Nirmala Devi. And subsequently another judgment I found.
Nothing, only one judgment is fine, place in the
Two judgment
record.
I have given to your lordship, my lord. But your lordship will find in the order itself, your lordship has recorded everything. 13 September order.
Yes, yes, two judgments. 2012 volume 11 and 2011 volume 8. Right there.
And your lordship quoted the entire order, man. Second chapter পেলাম না।
আগের দিন দিয়েছিল।
হ্যাঁ হ্যাঁ।
Yes.
There is subsequent judgment. Subsequent judgment, my lord, I found that is reported by Justice C.K. Thaket and D.K. Join. There, my lord, I'm just reading for your lordship because I have only 2 copies, my lord. If the court does not reject the petition on that ground, the court would be falling in its duty. In fact, such the act should be dealt with through a criminal contempt by initiating proceedings. Here, my lord, cost has been imposed 10 lakhs. Is also, my lord, fabricated document has been filed before the High Court, my lord, that has not been considered. Kindly pardon me, I have only 1 copy. Paragraph 36, my lord, the second page, your lordship, kindly see once.
Now, this is a case where the writ petition was there. There is no difficulty. But now here, since it originates from a civil proceedings, then so we have already stayed the order. And
After investigation, let the report be filed by superior person because there are something behind back. If the local OC, my lord, will make the investigation, nothing will happen. Some superior officer.
yes, just for
এটা পেয়ে গেল
IPC pattern. ম্যানুয়াল তো দিন ওখানে থাকবে IPC Egypt. এই যে কালপিট নিয়ে আসছে রিপোর্ট 192 of the Indian Penal Code. এই তো কত পানিশমেন্ট আছে 340 এটা না আমার ফোনটাকে নিয়ে চলে এখানেই হচ্ছে 193 7 years. This is 7 years petition. 192 into 7 years. Yes. 7 years imprisonment. 7 years imprisonment, we are directing. pursuant to the order dated 10/10/2023,
340 টাকা তো
the
কোনটায় হয়
constituted attorney
ভুলিয়ে ফেলছে সব।
of the plaintiff is personally present in court today. The counsel for the appellant, the counsel for the respondent, plaintiff respondent, on instruction received in the open court, submits that the photocopy of the death certificate allegedly issued by the Gram Panchayat was handed over to him by another person who is known to me. So it further transpires from the submission of the plaintiff respondent that the said constituted attorney has no acquaintance with the plaintiff, as he met her once or twice before the institution of the suit.
করছি দাঁড়াও না
It is really improbable and inconceivable that a person who does not know the party is acting as a constituted attorney and pursuing and prosecuting the case and affirming an affidavit verifying the statement made in the plaint as true to his knowledge. Several discrepancies have come in course of the hearing of the instant appeal. Apart from the forged and manufactured documents relating to the death of Harish Sen,
complaint to record a clear file
which needs a thorough inquiry.
which was committed in the
Stop.
absence
On the last occasion, the Aadhaar and the PAN card which was produced before the trial court indicate the date of birth of the plaintiff in the year 1970. On the other hand, the record maintained by the Kolkata Municipal Corporation relating to recording of the birth and death of a person within its jurisdiction revealed the date of death of the said Harish Sen in the year 1964. It raises a serious concern on the role of the litigant approaching the court with such false and fabricated documents and getting an interim order which causes immense injury to the other side or impedes the further progress in relation to a transaction. By the supplementary affidavit, the appellant has disclosed the letter issued by the Prangonjo Gram Panchayat in reply to queries raised under the Right to Information Act, wherein is indicated that the purported death certificate has not been issued as there is no reflection in the record. It is now it is further revealed therefrom that the said Gram Panchayat is started issuing the death certificate after 1997. whereas the death certificate relied upon by the plaintiff respondent is of a prior date.
Huh?
There is no ambiguity. No, it is that's there is no ambiguity and or doubt in our mind that the said death certificate has not been issued by the said Gram Panchayat, and therefore is false, fabricated, and manufactured for the purpose of this case. Though the constitutional attorney showed should not plead ignorance of the same as he obtained from a third party.
No, kindly mention the name
Third party, namely Rustam Sheikh.
of village.
But
Village
such
name?
stands appear to us contrary to the stand taken by the plaintiff herself on the last occasion, where she disclosed that the said certificate was found in one of the file relating to one of the file containing the documents relatable to her father, to her alleged father. On the last occasion, we noticed the judge. No, sorry, in Badami versus in Rameshwari Devi, Rameshwari Devi and others versus Nirmala Devi and others, reported in 2011, volume 8, SSC 249. The apex court, in a strong words, have indicated that there has been a rampant filing of the litigations based on the false and fabricated documents. And therefore, the perjury has become a way of life in the courts, in the Indian courts. In Badami versus Bhali, reported in 2012, volume 11, SCC 574, the apex court was also dealing with the identical case where the false and fabricated documents were used in the court proceedings and deprecated such practice and held that the court cannot allow its eyes to be closed to the facts, such facts, and a stern action is required to be taken in this regard. Even prior to the aforesaid judgment, the apex court in KD Sarma versus Steel Authorities of India Limited, reported in 2008, volume 12, SCC 481. The apex court held that the moment the court found that it has been deceived, there is no difficulty on the part of the court to refuse to hear anything further from the said litigant. And should take an appropriate steps so that the aforesaid act of filing the forged and fabricated document is not repeated. Obviously, the next paragraph. Obviously, the observations made by the apex court in the above reports is laudable and convey a very strong message in the litigating field that a person securing an order on the basis of false and fabricated document should be dealt with iron hands and should not be let to go scot-free. And walk merrily from the corridors of the court. We are reminded of the provisions contained under Section 191, Section 191 and 192 of the Indian Penal Code. Now, 191, 192 and 193 of the Indian Penal Code, which makes such act, small a, act an offense to be tried, to be investigated and tried as a criminal offense, and an adequate and the adequate punishment provided therefore should be inflicted. We therefore direct but she did not become a part. This application. 191, 182, 183, 420 to cheating. No, it's a prosecution under these provisions. আমাদের কাছে the prosecution under this provision. False, আমরা তো বলেছি false evidence. এখন কাকে দিয়ে বলবো? এটা তো কোর্ট প্রসিডিং হয়েছে তো কোনটা? না এখানে ডকুমেন্টস কোনো আছে সেটা তো প্রোভাইড করবে। জাজমেন্ট এনি বালাকৃষ্ণন সাহেবের জাজমেন্ট ছিল, ওখানে উনি বলেছিলেন যে এইভাবে করতে হবে। না নেই, আমি দেখতে পাচ্ছি না।
What is the name of it?
Justice Balakrishnan's judgment was there. Under these sections, 191, 192, 193 of the Indian Penal Code, where he suggested the modalities, how it is to be done, who will register an FIR. No, 340 is a different one. Here, once the court has arrived at the conclusion that এখানে বলছে sent to a 340 তে বলছে sent to a criminal court. এটা তো আমি করে দিয়েছি preliminary. Court বলছি, হ্যাঁ, send it to the magistrate. Execution তারও হতে হবে। Yeah. You file an FIR.
And later investigation be done, the report be filed before your lordship, my lord. On the basis of the same, we will definitely.
The appellant is directed to file complaint.
If
That's
we
a-
file an FIR, they will easily get a bill.
They shall file a written complaint which will be treated as an FIR. Treated an FIR within 5 days from date, indicating enclosing the photocopy of the death certificate issued by the Pranganj Gram Panchayat, Pranganj
Pranganj Gram Panchayat.
Gram Panchayat.
And the, my lord, the PAN card, that is also fabricated, forged document.
PAN card we do not know. PAN card may be there. We do not know.
I'll see PAN card
No,
number.
sir. That is a different one. Sir, there may be a multiple persons by the name of same person.
But this is reported in 2004 volume 8 Supreme.
This is what I really wanted. Justice Balakrishnan's judgment, 192, 193, This is what, give it.
But this is the judgment by Lakoti, GP Mathur, CK Thakkar, considering this, my lord. And Balakrishna judgment has been considered in this judgment, my lord. May I just hand up to your lordship, my lord? 1996, volume 3. Volume 3, 533. 1998.
Where the modalities was provided, how to do it.
1998.
Anyhow, we are directing you to make within 5 days from that, enclosing the Panchayat. Stop. Immediate and investigation shall be done in this regard.
In between some superior person, there is something behind that.
Investigation shall be done in this regard by a responsible officer appointed by it is which district?
District 24 Pargana South.
So there is an SP by the Superintendent of Police, South 24 Parganas.
No, SP Baroipur is separate. SP Baroipur is different, my lord.
Baruipur is not a separate district.
But
Is a subdivision, I believe. Is it a police district?
yes,
So there is an SP.
that is
Additional.
Superintendent of Police Diamond Harbour. Under the Diamond Harbour,
So there is one SP. And there may be multiple additional SPs.
SP Baroipur is there. SP Baroipur is there.
Superintendent of Police, Baruipur. And
1992 এটা রেফারেন্সটা বলতো 1992 এর একটু পেজটা বলো যেটা তুমি লিখলি মাত্র
and
1992
7 বছরের up to 7 years to before CJ to up to 7 years. So after completion of the investigation, the charge sheet shall be filed before the Chief Judicial Magistrate. 24 Pagna South. And thereafter. Yes, sir. We expect that all course of action required under the relevant procedural law as well as the substantive law shall be completed as expeditiously as possible without any unreasonable delay. Reverting back to the merit of the instant case, the claim of the plaintiff relates to a right, title, and interest in respect of the property inherited by her from her father, namely Harish since decease. And an ex parte ad interim order of injunction had already been passed. Keeping in mind that the Harish since decease had a right, title, and interest in respect of the property, plaintiff being the daughter has a right therein.
And therefore, the respondents should be restrained from. Where is the nature of the order?
With the memorandum of appeal, my lord. Nature is, my lord, plaintiffs and defendants maintain status quo in respect of their respective.
And therefore, কি বলেছি? No, and therefore the parties to the proceeding should. Maintain a status quo in regard to their respective physical position, nature and character of the suit property. Full stop. At the time of admission and considering, we have stayed the order.
Yes, my lord.
And considering the prima facie case having made out by the appellant, we state the operation of the order on
13th September.
13 September 2023. Since the entire claim is founded upon the inheritance, which on the disclosure of the documents by the appellant before us creates a strong suspicion and the doubt, as the said Harish Sen, since deceased, was shown to have died in the year 1964 in the record maintained by the Kolkata Municipal Corporation. And the PAN card as well as the Aadhaar card relied upon by the plaintiff indicates the date of birth in the year 1970. It is improbable and inconceivable that a person who died in the year 1964 shall have a child born in the year 1970. Furthermore, the date of death of the Harish Sen, since deceased, was shown in the plaint as 1/1 or 85. What is this?
1185.
1/1/1985. On the basis of the death certificate purportedly issued by the Prangonjo Gram Panchayat, which is fabricated and manufactured. And therefore, the order passed by the trial court cannot be sustained. The same is hereby set aside. Liberty is granted to the parties to take appropriate steps in the said suit.
But only thing I will prefer some cost in this matter. Any cost. Because that
Considering the gravity of the issues as disclosed here, as discussed herein above, the instant appeal is dismissed with the costs.
allowed.
Allowed with the cost assessed at rupees 2 lakhs to be deposited with the State Legal Services Authority within 3 weeks from date. In the event of a default in payment of the said amount, the trial court shall not only refuse to proceed with the hearing of the injunction application, but the State Legal Services Authorities are permitted to proceed under the Public Demand Act. What is this full form?
Public
West Bengal Public Death Recovery Act. Public Demand.
Public Demand Recovery Act, my lord.
Public Demand
1913,
Recovery Act,
my lord.
1940.
1913.
Recovery Act, treating the operative portion of the order as certificate.
My lord, it's the Bengal Public Demands Recovery Act 1913.
Yes, that is. Bengal,
Bengal Public Demands Recovery Act 1913.
1930,
1913.
1913. As a land revenue. As certificate. As land revenue.
Great.
I am appealing for the appellant.
What is this application, sir?
Well, application for an order of stay and for interim maintenance. Well, suit has been decreed. Well, divorce granted, my lord.
Hey,
Against that, the appeal has been preferred. Before, my lord, on the last occasion, there was a direction. To file an-
say that. Interested party, aggrieved party. This is the way to present the case. You are not a party to the proceeding. What is the nature of the decree?
Decree was, my lord, letter of administration was granted.
Letter of administration granted.
Prior to that,
By whom?
by the, my lord, additional district judge, fast track, Srirampur.
I asked this question only for the purpose whether appeal is there. And there is also a delay.
Yes, my lord. In that case, my lord, delay we have wrongly computed. We have said it is nearly 52 days delay, but
Anyhow,
department,
37 days
Yes.
delay, but you'll have to serve the copy.
yes, we will serve.
The appellant is directed to serve the copy of the application being Can 1 of 2022 and Can 2 of, sorry, the applications being Can 1, Can 2 and Can 3 of 2022. Upon the respondents by speed post and shall file the affidavit of service on the returnable date. The application is made returnable 1 week after the reopening of this court, following puja vacation. Yes, call the next.
Please, your lordship. Question for the appeal.
What is this application vacating?
Lordship, one is for vacating, my lord,
But I am for the respondent husband.
and my lord, Can 4 is for my lord, an interim maintenance of the wife, my lord. But this is an appeal
Section 5 allowed?
allowed, my lord. Appeal has been admitted. And my lord,
And not admitted, but allowed.
allowed, my lord. And there was one interim order of stay, my lord, for 12 weeks. Pursuant to order of my lord on 19/5/2023, my lord. The
19th,
May,
19th May. Just 1 minute.
lordship.
It's a case of restitution of conjugal rights.
Allowing the, my lord, decree, allowing the restoration, allowing for restitution of conjugal rights in favor of the husband, my lord.
Why you do not want to live with your husband?
My lord, this, my lord, the petitioner has been, my lord, the appellant. I beg apology,
Hey,
lordship.
It's a matrimonial procedure.
Thereafter, Service Commission appointed by the learned court below.
Preliminary degree challenge?
No.
Here in this court? Yes, give us the number.
Preliminary degree.
Yes, give. Don't shut him.
No,
When he
my-
says filed.
He is
He
not-
will give a
he is
number.
not correctly stating the facts. I
He's
may
not
be
correctly
allowed to
stating
state the facts. I shall take only 5 minutes time.
5 minutes in an hour.
Preliminary degree was passed.
What is this
Preliminary degree not
application?
challenged. Final degree was initiated by the plaintiff. Partition commissioner was appointed. Narayan Ghosh Jossidar, he submitted a final report. That report was challenged. Again, learned court below appointed a second commissioner. Second commissioner, after inspecting the premises, submitted a report, final report. Final report has not been challenged, kept abeyance for 4 years. Honorable court directed the learned court below to dispose the final degree proceedings within a firm of fixed date. Thereafter, final degree proceedings was fixed for absence of the, kindly turn to page 66. 66.
Then what happened? Then
Thereafter, final degree it was accepted by the learned court below. Final degree was passed. Final degree proceedings ended.
mere passing a final degree proceeding does not end anyhow. Then
Final degree, kindly see the page 68. Same is decreed in final form in terms of report of the
Correct, that does not mean it this list is ended
And
unless the
degree was
final
what?
degree is engrossed on the stamp paper.
I have already put in, I have taken the final degree.
Then
That are ended, disposed of. Suit, final degree proceedings ended and disposed of. My learned friend came up with an applications under 9 Rule 13. 9 Rule 13 on the grounds that when the date was shifted back from 29th April to 21st January,
it was not known to him.
he was not informed because fact remains from the order sheet, it was informed. Learned trial court, after getting the fact report and the service, directed the defendant to show cause, and partitioner commissioner was directed to appear on the witness box to give evidence in respect of the report. On that day, kindly turn to page 67. None appeared. Even partition commissioner did not appear. Defendant did not take any steps. No show cause. Kindly see page 68. That is the final order of the learned court below.
Yes.
Page 68. I have meticulously perused the commissioner
What is
report.
this miscellaneous case number 78 of 20?
913, order 9, rule 13, after disposal of the final degree proceedings.
But that has not been allowed as yet.
Section 5 accompanied with the order 9, rule 13 application. During the pendency of the application section 5, they moved an application of injunction, praying that I may not take possession of the allotted property given by the partition commissioner.
Now tell me whether appeal lies if an injunction is passed in a proceeding under order 9 rule 13.
That is a partition suit.
It's an order 9 rule 13 application.
Interim order
That's
injunction was allowed.
another, I am asking Mr. Ghosh, I am talking law in a proceeding originating from an application under order 9 rule 13. If an application for injunction is filed, whether it is an appellable order or not an appellable.
The appellable order, lordship subject to law.
Show me the law. Any
We
judgment.
have ordered 40 rule on sub rule law, which is an appellable order.
Sir, if the relief against the final, now principle is, if the relief against the final order is not appellable, whether a relief against an interlocutory order is appellable. Tell.
Injunction petition was
Right from Sir Asutosh Mukherjee's judgment, and the latest was Justice Bhaskar Bhattacharya's judgment. Tell me, show me the law. Contrary to it, we are ready to accept. Show me.
Then, I'm not armed with the decisions, but the appellable order.
No, don't take a plea under order 43 rule 1R. Again, I'm saying the principle is that I have said. Dismissal of order 9 rule 13 is not an appellable order.
This is that it was allowed by the learned court below.
No, order 9 rule 13 has not been allowed as yet.
Order 9 rule 13 has it is yet to be allowed after disposal of section 5.
Sir, how can you presume the court after looking into it may reject it?
But during the pendency of section 5 interim order of injunction.
I am again saying I can, but you have to choose a forum. Have you chosen a correct forum? I am asking you a very simple question.
Valuation, my lord, 20 lakhs, my lord, should value, my lord.
Can it be on that ground? Again, what I have said, that if the relief, if the remedy against the final order is not an appellable one, whether an interlocutory order passed in such proceeding is appellable, I am asking you this question.
Then, my lord, I have
Answer me.
my lord, kindly, I have to cite certain decisions, my lord.
Cite it.
My lord, kindly.
You don't know any decision as of now. You want to cite a decision. Even you do not know this principle.
But the
And
valuation.
you will say that you will have to cite a judgment. Satisfy us on this point.
My lord, kindly fix it on 10:30 Monday, my lord. Monday, my lord, kindly.
Monday. Satisfy us on this point.
My lord, at 10:30, my lord.
Why?
2 PM, my lord, the matter is fixed.
Not 10:30, because we will be adjusting it, one half for order 41, one half for application. That you will get an indication. তো বেটা কাজ করো, তুমি ফার্স্ট হাফটা অ্যাপ্লিকেশন করে দাও, সেকেন্ড হাফ অর্ডার 41 করো। From Monday. Monday to Thursday. Monday to Thursday.
Bill number I is providing in the.
Please give. Next.
That appeal has become infructuous. Proceeded with the final degree proceedings.
Mr. Parthopratim Roy, bring those line of judgments where it says that from the main relief, if the remedy from the main relief is not an appellable, then interlocutory orders passed in such proceeding is not
Not
available.
available.
Give him a judgment of Justice Bhaskar
Sir,
Bhattacharya and prior thereto of Sir Asutosh Mukherjee. Old judgments.
If the main relief is not available, then interlocutory order cannot be.
Even if under order 43. Give him that judgment. Yes, next.
Those judgments were referred.
Give him that. He will cite some judgment without knowing the principle of law. So give him first the principle of law, then let him cite the judgment. Yes, next.
My lord, praying for not today, my lord. I am for the petitioner, my lord. My senior counsel was just appearing in the court. but
After
left
vacation, madam.
Not today.
After vacation. Yes, accommodation is sought. Let this matter be listed after vacation. Next.
117, my lord, in this matter, my lord, I am appealing for the appellant. This is defect which has been recorded is that the name of the performer is in state of West Bengal has missed
Complete and after limitation.
after elimination.
So you'll have to.
Performer, my lord,
No.
no relief has been claimed, my lord, nothing else. The suit for partition,
Preliminary degree.
suit dismissed. Because, my lord, this is a refugee rehabilitation
What stay? What application?
injunction.
What
Application
injunction?
not to disturb because mother and
Whether
daughter.
you were enjoying any injunction during the pendency of the suit?
No, we have prayed. No,
Did- So
I could. Let me serve. So
serve, come back 1 week after vacation. Next,
and so far addition, my lord, can your lordship may I grandly
take our application.
application.
Next,
কবে থাকবে? Better to appear, my lord.
1 week after vacation. Yes, on the prayer of the appellant, after 1 week after, after vacation. Next,
181, my lord. The learned advocate, Bhaskar Ghosh is appearing online, my lord.
he's appearing online.
My lord, I am appearing online.
Yes. Yes, what is this? Tarak Prasad Bhagat.
My lord, this is your lordship kindly see your lordship's previous order that the revision will lie against this. And not
No, there is no order. There is no order passed in this.
No, my lord, what happened is matter is pending in the monthly list of Justice Sampa Sarkar as item number 850. But we cannot have it heard, my lord, because before the vacation, but the matter has been fixed in the trial court on 23rd of November. And the final degree will, my lord, evidence will be proceeded.
So let it appear immediately after vacation if you can get it done before that.
There is no possibility, I don't think, my lord. Her lordship, my lord, is not inclined to give any upgradation. Previously, my lord, her lordship, my lord, said that unless an order is passed by the division bench that the appeal is not maintainable, then I can take it up. But after we mentioned before your lordship, again we mentioned there that this is automatically, she has got jurisdiction to entertain it because appeal doesn't lie, revision will lie. And we have filed this alternative application. Or not, if it otherwise
against which you have come?
My lord, if it is otherwise available, my lord, let there be an order, my lord, directing the trial court not to proceed with before the.
I am asking you, Mr. Ghosh, please face the camera. You are facing reverse of the camera. On the left side.
Yes.
No, your camera is still not there. Your camera is not there. Yes, yes. Now you are facing. Correct. Now again. You are
My
facing.
Lord, what I am praying, my lord, your lordship kindly direct the trial court, my lord, to adjourn it further till the revisional application is disposed of, which is pending in the list.
What is this appeal? Against which order this appeal is
My
filed?
lord, this is a preliminary degree.
Order dated 31st May 2023. This appeal.
23rd?
31st May 2023.
But the matter previously came up before the honorable court, and
It is a revised order.
yes, a defense was struck out.
No,
because it
ordinary
could not-
degree stands revived.
Yes.
Why it stands revived?
They have
Mal-
not complied the High Court, sir.
By order dated,
But this order is not applicable.
Yes.
Uh,
No,
this
no,
order-
that's why, my lord, we have filed already the, after.
No,
hearing
no,
your
then
lordship's
in a
view, we have
incompetent,
filed an
Mr.
application
Ghosh,
with
Mr. Ghosh,
alternative application.
Mr. Ghosh, in an incompetent appeal, whether any interim order can be passed.
Yes.
I am asking very simple
Then
question.
the client will suffer, my lord. 23rd is the November is the date fixed.
No, yeah, you get it, because if you say, then we will invite you to first argue on the question of maintainability.
on the other day, my lord, your lordship heard at length.
My lord, it's on the ground of maintainability, if your lordship was of the view that appeal does not lie, revision lies.
Correct. This is also our view now.
In view of that, my lord, we have filed an alternative application. for
I
revision.
understand, then you'll have to go before the court, because we are of the view that it is not maintainable.
Right, my lord. That's why I filed an
So
application.
we will not file, will not pass anything.
My lord, we have filed an
What
application
is-
that is pending, but the
No,
judge
Mr. Ghosh, the difficulties I tell you, we have not come to a concrete, decision whether the appeal would lie or it will not lie. And if you have alternatively, for abundant precaution, have filed the revisional application, you know what used to be done earlier. You know what used to be done earlier.
My lord,
You have not
It
advised,
hurt, my lord.
not
as per the
advised your junior to do that. You have not advised your junior to do that.
No, I came in later, my lord, much later. That's
No, then,
before that, my lord, one set of proceeding was concluded before this honorable court by Justice before Justice Somen Sen sitting in the division bench.
It is a suit of 2020, 2002.
And only question is, my lord, since we have not filed the original documents, my defense has been started.
My lord,
That is my only fault.
what is required, sir? What we learned from you in this regard? What we learned? Should we remind you that what we learned from you in this scenario?
My lord, we have prayed for time, my lord, before the trial court. But they
No,
are
it's not that I am
And
talking.
we mentioned, my lord, also before Justice Sampa Sarkar.
No, for that I am not saying at all what is required. Suppose if there is a dispute or there is a confusion whether an appeal would lie or a revisional would lie, what we learned from you, that it is better to file both appeal and the revisional application.
Yes, that we have filed along with the,
Learned further.
my lord, we have already filed that application, alternative petition to that
Then
deal.
what we learned further from you.
My lord,
that-
then your lordship kindly take it up, my lord, the appeal itself,
Is it? No, you have forgotten that.
along with the application.
No, it is wrong. You never taught this.
not maintainable, then
Appeal, my lord, along with the alternative application. Your lordship, and since this is
not.
So what is to be done? Now, when you said this, then what is required?
but that application has got to be disposed of.
Uri?
Revisional application should be filed along with my lord B form so that may be listed before your lordship. But
It
instead of
cannot come. The proper course would have
Yes.
been to get the matter delisted, approach, and then get this revisional application assigned along to be heard along with the appeal. That is what we learned. Mr. Ghosh is not saying that. So that even if we hold that appeal is not maintainable, revision is assigned, the court can enter into the merit. Or if it is held that the appeal is maintainable, then revision application will get dismissed and the appeal. This is what we learned. And that is a proper course.
required to be filed.
That is the proper code, no doubt, my lord. We
So
have already
why you are not? We will
We
not pass an order in this regard. Mr. Ghosh, to be very frank, And we are absolutely sure about it that appeal is not maintainable. If you insist, then we will hear out and then decide the matter here and now on that ground. We don't know what impact it will have on the revision.
Then Malad, kindly fix it after the vacation just.
Yes. Let this matter appear 1 week after the.
Malad, 23rd November is the date fixed in the trial court.
Please get those process done. It's very easy to get it done.
All right, my lord. Since my difficulty is my junior is not coming to court, my lord. She is doing all the time from online.
Who is your junior?
My lord, Maiti. She is on the screen. Mrs. Maiti.
Maiti is there.
Her.
Sorry, Milord. Sorry, Milord.
I would not,
I am later.
not
I have come
use the
later.
word alter ego, but all the commandos are here.
My lord, I could not go to court. I am sorry, Milord. I am sorry, Milord. I want to go there, Milord. But
Whoever is working with her, everybody is appearing in the court.
That's true, Milord. That's true.
She is, my lord, physically possibly some difficulty.
Some problem is there, Milord. That is why, Milord. I want to go there, Milord.
Regarding her movement, my lord, she is in some difficulty. That's why, my lord, she is not attending.
No, we appreciate. We always encourage that if somebody wants to do it virtually, even there was no mandate from the day when the virtual hearing started, we are, at least I can share with my brother also, we never say anybody no. It's a good technology. Everybody should embrace the technology and give an impetus to get it more advanced in future. Yes, come after vacation. Next.
My 182, I am for the appellant. My 182, I am for the appellant.
What is this Can 1?
But I filed an application for grant of probate. That applicant has been turned down on the ground, but only on
What order you want? We are not.
not to create any third party interest. That has
Who
been.
are you?
But I am the beneficiary. I am the son. And now I am the adopted son. Thou court below, while considering an applicant for grant of probate, has said that whether my adoption is right or wrong, that has to be decided first. No matter what we learn, my lord, in the probate court to decide whether the will is genuine or not. Not beyond that. Kindly see the order, my lord. And for the timing, not to create any third.
No. Who is for the other side?
First time coming. Kindly see, this is.
Going to the toucher. Even an outsider or stranger can be a beneficiary under the will.
The court has specifically found whether my adoption is right or wrong. Kindly see the last but one page. Therefore, this learned court holds safely that the petitioner completely failed to establish that he was a adopted son.
This was a letters of administration proceeding. Executor.
My father, executor, not letter of administration. I filed an.
I find.
What happened, my lord? There are two persons. I am one of the beneficiary. I wrote a letter to the executor to file an application for probate. She did not. Then I give a notice.
Who is she?
She is my lord, the
cousin sister.
Now she did not. Therefore, I filed this application. Now court is of the opinion that my lord, I have to prove whether I am an adopted son or not.
A letter of letters of administration proceeding is turned down by the trial court solely on the ground that the applicant has to prove that he is an adopted son of the testator or testatrix.
Testator.
Testator.
Originally কাটছিল।
It appears that the applicant of the said application is sole beneficiary or one of the beneficiaries?
I'm one of the beneficiary.
Is one of the beneficiary under the said will. Who's under the said will. Full stop. It is the instant application is taken out, seeking an order of injunction, alleging that taking advantage of the dismissal of an application for letters of administration, the opposite parties are attempting to transfer and alienate the property, which is a subject matter of a will. Stop. In view of the above and the facts as indicated here in above, more particularly the ground on which the letters of administration was refused, we feel that in the event the opposite parties are, now we prima facie find that in the event the opposite parties are now our opposite parties are succeeded in creating an interest, it would have an impact on the estate of the said testator. Accordingly, the opposite parties number 1 and 2 are restrained from transferring and or alienating the suit property, being the subject matter of the will, in favor of a third party for a period of 10 weeks from date or until further order, whichever is earlier. The appellant is directed to serve the copy of the application by speed post and application is returnable 1 week after vacation.
Grateful.
My,
Grateful.
my lord, regarding item number 191, my lord, only direction to service, my lord. Section 5 application.
We will be taking up on Monday. We are taking up everyday applications. Don't worry. From next matter,
My lord,
183. That 176 টাই তো আছে দুটো ম্যাটার শুধু আছে সেটা দিয়ে দিও বাকি
my lord, in item number 4, my lord has passed an order, my lord, the cost of rupees 2 lakhs, my lord, that would be, my lord,
আচ্ছা ওটাকে 5 লাখ করে দাও Apex Court imposed 10 lakhs in this regard. We imposed only 2 lakhs and you are saying
that lady, for that lady to pay this.
whatever.
হাওড়া জমি
Yes.
আগে ছিল নাকি? আসে না, যায় না।
কল করতে দাও।
কল করে নি।
এই কল করো। ও কি চেঁচাবে না?
None appears in support of the contempt application. The petitioners, the applicant, as applicants have alleged willful disobedience and deliberate violation of the order of a division bench in which one of us, Amanna, was a party. Such order was passed in MAT number 219 of 2017. The matter was assigned to this bench. By order dated September 21, 2022, the applicants were directed to appear when an order, the applicants appeared on September 21, 2022. This bench directed service of the contempt application upon the alleged contemners. Matter was made returnable 2 weeks after the Puja vacation. On November 11, 2022, this bench recorded that the earlier order of service of the contempt application upon the alleged contemners had not been complied with by the applicants. As a last chance, matter was
Your Lordship, I am for the
returnable on
petitioner.
December
Item number
16, 2022. Yes,
Ma'am, my senior asked me to urge you to make it after vacation.
show service, please. Have you served?
Yes, sir.
Have you served the contempt application?
Yes, sir. Yes. Yes.
You have?
Yes. Item number 1.
Will you be thought contempt application of the, to serve the contempt application? Have you served?
Yes, madam. I have served, madam. Thereafter, madam, they have taken out a review application, madam, which they have never moved.
Who is the they?
Madam, the union government.
I'm appealing for the union.
There was a direction to implement the welfare scheme of the for the BD worker, madam.
Review against whose, the earlier order of this?
Yes, yes, madam.
ঠিক আছে, তাহলে এটা complete the dictation. Mr. Singhania, are you appearing?
I'm appealing Union of India, madam.
Have you filed any review of this order of the earlier order?
Well, we have filed an earlier review, madam. We have to search it out. It was 2018, madam.
One Shubhankar
That is
Chakraborty
pending
was
This
appealed.
Review of the order passed in MAT number 1493 of 2017.
Yes, yes.
Yes,
Okay.
but here this
So
application,
will you also take service on behalf of the Khali?
of the number 7 and 8, madam.
Ministry
of Labour and-
Since they have not taken any steps for to move the review application,
Show us the affidavit of service.
yes, millet. Millet. This is the letter.
No, service upon the
This is
alleged
subsequent letter
contempt.
possibly, millet. The contempt has been filed since the authority deliberately did not comply with the order so passed in meeting number so. Then millet, we have referred the CPN number. And millet, this matter was in fact assigned upon notice, millet.
No, Mr. Ahmed, last two occasions we directed service. On the last
Where is that
occasion,
service?
last chance.
Millet,
Today, the
as I have been informed that
advocates for the applicants have failed to produce any document to satisfy the court that the service of the contempt applications upon the alleged contemners as per the order dated November 11, 2022 has been effected. Mr. Singhania appears on behalf of the Union of India. Copy of the contempt application. Are they contemners? Union of India also contemners?
yes, millet.
Who is representing Union of India in a contempt application?
But no name has been given regarding that.
Huh?
Student number 7-8, the labor officer was something like that. No name has been given. Student number 7 and 8.
Shomik Board, Kapurgachi, Molai Bhatt. Nah. Is Director General Labor Welfare. Are you representing him?
Number 7 below copy has been served. One copy has been served. on
7, there is no
number 7.
7 in the contempt application.
He's saying
The
respond number
contempt
7.
in the call, forget about the
Yes.
title of the read. Or the
Welfare Cess
big
Commissioner.
Contempt application, there is only Santosh Kumar Gangwar, Director General Labor
Welfare.
Welfare.
Yes.
So you will represent him.
I represent him. Then there is no name in the contempt application. It is only the Director Ministry of Labour and Welfare.
No, there is a name, Santosh Kumar Gangwar. Mr. Ahmed, but service has to be effected. Twice we have.
But,
I
I've been,
don't think you're interested in.
but I have been informed that the clerk has going for affirmation, but there was someone misplaced.
One second.
The long.
Fresh service should have been
Number
done.
5, there is no name in number 5.
Acha, okan likhun, Mr. Singhania, learned advocate, appears on behalf of the alleged contemptor number 5 and prays for a copy of the contempt application. Let a copy of the contempt application be served upon the advocate on record, appearing on behalf of the opposite, the alleged contemptor number 5 here and now. Give him a copy. Service upon the opposite, alleged contemptor numbers.
He has received a copy, millet.
You have.
Yes, he has already received a copy.
One copy I have served here in Calcutta office.
তাহলে আর কপি সার্ভিসের দরকার নেই upon the 1 to 4 করে দিতে বল কবে রাখবে তুমি চলে যাবে after the আমার তো সার্কিট আছে না আমার সার্কিট আছে জলপাইগুড়ি করতে আসবে second week of December. Affidavit of service
Service টা complete করে
upon effecting service of after effecting service upon the alleged contemptor numbers 1 to 4 shall be filed in court. Please,
Okay,
that,
sorry, ma'am.
otherwise we can't take it up.
I follow.
Yes.
It's first time appearing, my lord. Order dated 8th August 2018, my lord. Passed by Honorable Justice Debasis Farooq and my lord Justice Sarkar.
First time. When did
First
you
time.
make?
Relevant portion in the page 30, my lord.
Yes, service upon of the application upon the alleged contemner.
My lord, subsequently, my lord,
Review আছে নাকি? Review আছে? ফাইলটা সেকেন্ড ফাইলটা আছে তো? সেদিন মনে হয়। না আমার কাছে তো একটাই কন্টেন্ট।
রিভিউ ফাইল এসছে? হ্যাঁ
একটু দিন তো।
হ্যাঁ
জানি না। রিভিউটা কি ডিসপোজড অফ? রিভিউটা তো দাগ দিয়েছে কেন? হ্যাঁ। এটা নিশ্চয় শাহ নয়? হ্যাঁ? তাহলে একসঙ্গে দিল। ও তাহলে অন্য ফাইল।
নিজের মতো করেছে।
Lord, subsequently, my lord,
এটা আলাদা মামলা। হুম, না, 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 ঠিক আছে, ঠিক আছে।
alleged contemner has been transferred, my lord. The new incumbent is takes charge. Liberty may be given to incorporate his name, my lord.
Liberty is granted to the petitioner. তাহলে এটা শুরু এইভাবেই হবে। Liberty is granted to the petitioner to add the present incumbent to the post of the
PLRO, Block Land and Land Reforms
Block Land
Officer,
and Land Reforms Officer Bali.
Jogacha.
Bali dash Jogacha.
Presently, my lord, Kosik Chakraborty is the BLRO, my lord.
Service upon the added alleged contemner. Oi, second week, let the matter appear on in the second week of December. Affidavit of service.
My lord, Liberty may be given to incorporate the new incumbent, my
I
lord.
have said that.
My lord, I am grateful to you.
Both, service both.
Service upon both. Alleged contemner number 2.
Hey, service upon both.
Both.
I am grateful to you. Both বলছে।
My lord, I am for the petitioners, my lord. Not only the alleged contemner number 3 has retired from service, but the other 2 alleged contemners have also retired from service. I have ascertained the names of the new incumbents. I want to include them as added alleged
Is
contemners.
this the first time?
No, my lord. Rule was issued.
Oh.
Rule could not be served due to retirement of the person concerned. That's why, my lord, your lordship has been pleased to, my lord, to direct me to ascertain the name of new incumbents. Now it has come to the knowledge.
Yes,
the
take down.
alleged contemners.
service of the liberty is granted to the petitioner, to the applicants to incorporate the present incumbents to the post of
1, 2, 3. Both
Chairman Bharat Sanchar Nigam Limited, Chief General Manager and the Assistant General Manager of Bharat Sanchar Nigam Limited, Chairman, Chief General Kore of, as alleged contemners numbers 4, 5 and 6. Service of the contempt application upon all the alleged contemners. Affidavit of service to be filed on the next date. Let the matter appear on in the second week of December. Serve all.
I filed affidavit of service in the next.
Yes, yes.
Access the channel. Access the channel.
Link it.
Lordship, Mr. Basu is appearing virtually in this case. For the applicant, for the petitioners. Mr. Kollol Basu.
Yes, what is this?
I'm here.
Mr. Kollol Basu appeared.
My lord,
Okay,
my
my lord.
lord,
No, he
the
writes.
order dated.
Basu. What he writes?
Bose. Basu.
Ascertain whether he writes Bose or.
My
Ascertaining that Basu.
my lord's kind leave, my lord, to file a supplementary affidavit, my lord, certain documents.
Mr. Basu, your internet connectivity is very poor. Please enhance the bandwidth. No, we can't hear you.
I'm sorry.
No, we can't hear you. Your voice is coming in a distorted manner.
Lordship, I am.
Tell him over the telephone that what is the problem we are facing.
Can't hear you.
We can't hear him because we are not getting his voice. You can see.
Mr. Lahiri, you are appearing for who?
The contempt. The contemners.
All of them.
All of them, my lord, first, my lord. The contempt number 1 and 2.
My lord, 1 and 2 have not responded to the contempt. Despite there being a direction, my lord, and at the outset, my lord, I seek my lord's kind leave to file a supplementary affidavit.
Are you representing 1 and 2?
I am representing all.
All.
My lord, I
So,
have to
no
I have to
difficulty.
submit that 1 and 2 may be expunged because they are the revenue secretary and the chairman of CBIC. They have no role to play, my lord.
No. There is one is the secretary, Ministry of Finance,
Revenue.
Department of Revenue,
Yes.
and another is the Central Board of the Excise and Customs.
Chairman of the CBIC. But they have no role to play in this, my lord.
CBI
Central Board
of Excise and Customs.
Yes.
What is the matter about?
But matter relating to promotion.
In a
My lord, the order dated 24 July 2018. Am I audible, my lord?
now, to some extent.
It is
My lord,
the
my lord, the order dated 24 July 2018, my lord, if I may take my lord's kind undivided attention to the order, my lord, it defines a specific contour of the grievance of the lead petitioner before your lordship. My lord, 24 July 2018, page 35 of the contempt application, my lord.
No, it says that the operation of the such and such office memorandum shall remain state.
Yes, my lord, thereafter on 2nd September 2020, Mr. Lahiri's client, he my lord wants to expunge from the contempt proceeding, Milord, from their official website, a seniority list was published, which is a replica of, Milord, the seniority list, which was, Milord, published in 2015. And such list, Milord, by
What
virtue
is
of
the violation? Suppose what Basu, what is the violation?
violation is, Milord, that the 25th seniority list, Milord, was stayed by your lordship's order, Milord, because that was absolutely in violation of the rules. Now, Milord, what happened? After the order was passed on 24 July 2018, Milord, the central board, Milord, the chairman, according to our perception, Milord, from the official website, in the year 2020, September 2020, Milord, they published a list, Milord. The chart has been given here, Milord, which is a replica of the same seniority list that was published in 2015. Milord, that is one aspect. Whether this can be done indirectly, which could not be done, Milord, directly. Milord, that is Milord, a violation of your lordship's order, which is in full and deliberate. And this honorable court, subject to correction to be made by my learned esteemed friend, Mr. Lahiri, that Milord 1 and 2 were directed, Milord, to file affidavit. Milord, it is between the contender and the court. Petitioner is a mere relator, your lordships know very well, better than I. Milord, if in the event this honorable court finds that 1 and 2 had no knowledge and no role to play with regard to the publication of the seniority list published on 2nd September 2020 from the official website of the central board, Milord, the question of expunging, Milord, these two alleged contemners, Milord, will arise. But today, it is too late in the day to argue that when the direction was made upon the parties that they would pray for expunge without any application, only on the oral submission.
Is the
Number one.
situation of the OA? The order was the list will be stayed till the OA is disposed.
OA is heard and order is awaited. OA is final
And order is?
awaited for final judgment.
So what Mr. Basu is saying is that you have violated the order because the seniority list was published.
No.
No, let them say.
But I am filing my affidavit in respect of 3, 4, and 5.
All right.
May I file, my lord?
Milord, 1 and 2 may come, Milord, before your lordship saying that 2nd September 2020 has no reasonable nexus and no matter of ordinary prudence could come or arrive at such a conclusion that 2nd September 2020 is directly relatable to the list that was stayed by the High Court. Let him communicate his stand to your lordships.
Who published the list?
One joint commissioner.
Your lordship that
is not
I
a
can say, and this is the violation. And I know, Milord.
Mr. Basu, how is the Secretary Ministry of Finance responsible for the publication of the list and the chairman of the Central Board of Excise and Customs? Tell us, the others have filed an affidavit. Why are we not going to hear them only?
শুনলোই না
কি করো তুমি ফ্রিজ
ফ্রিজ হয়ে গেছে এখন এখন আবার রেস্টোর হয়েছে বলে দাও
মিস্টার বাসু
এটা বন্ধ কর না, আমি কিছুই শুনতে পাচ্ছি না, চাচ্ছি না তো মামলাটা নষ্ট হয়ে যাবে। দেখ না, ওটা বন্ধ করতে হবে।
Where is the list? Show us the list which they published, which according to is violation of the order of High Court.
2nd September 2020.
Page. Where is your brief? Take it out and show it to us.
Starts from page 44. The list is at page 46.
Okay, 46. Joint Commissioner.
Signed by Joint Commissioner and Assistant Commissioner. They are not parties before this. In contempt.
They are not holding the office, my lord. The list or eligibility list has been published from the board's website.
My
And
lord,
we
your
have-
lordships. My lord, your lordships know, my lord, that even if, my lord, a person is not a party in the proceeding, the knowledge of the order, my lord, is sufficient, my lord, in order to initiate a contempt proceeding against that person. The question is, my lord, the 2nd September 2020, if it was published on the official website of the board, and the board was armed with the knowledge of the order dated July 24, 2018, then the question of feigning ignorance, my lord, is a mere pretension to avoid, my lord, the contempt proceeding, my lord, initiated by the High Court. It cannot be said, my lord, by any stretch of imagination, my lord, that even if they were not a party in the proceeding, they did not have any role to play in this matter. Because, my lord, I am told, subject to correction to be made by Mr. Lahiri,
What was
that
the memorandum dated November 30, 2015? Show it to us. The memorandum of the seniority list which was stayed, what was that? Show it to us from the papers, please.
Okay. Well, it is not annexed.
the order has been passed, my lord. And that order has been annexed to the contempt.
Was,
That seniority list has not been annexed to the contempt petition, my lord.
how will we otherwise
Because-
understand that the seniority list which we stayed, which the court had stayed?
The-
1 minute, please, let us make ourselves clear. The order that was passed by this court is a office memorandum of November 30, 2015 shall be stayed till the tribunal hears out the original application. According to you, this DPC, they had a DPC, and after that, a promotion list to grade A of superintendent from inspector was published. You say it was uploaded in the website of the board.
Good.
Thus, everybody who is connected with the board are contemners. Now you have to show us that this order of the memorandum of November 30, 2015, how is this a violation or a subsequent development, or it's the same list which was stayed been uploaded again? For that, we have to see what is the contents of the memorandum of November 30, 2015. So show us that.
Lordship, memorandum is that memorandum is the seniority list.
Where is that?
Seniority list published on 30th September 2015.
Show it to us. We have to see whether this seniority list is the same as that. If that is your case, then you have to convince us that what was stayed by us has again been repeatedly uploaded by giving.
We have annexed one comparative study, my lord.
Where
A
is
comparative list of 2015 and eligibility list.
Where
That
is
is annexed to the contempt petition, my.
Where is your brief?
Con-
Your brief?
Is lying with Mr. Basu.
Peace with Mr. Vasu.
Photocopy 2 copies at least.
My lord, certainly it is time, and he has gone to the Supreme Court.
Where is the comparative?
Annexed to the contempt petition, my lord. Annexed to the contempt petition.
Which page?
Hmm?
Mr. Lahiri, this is the only point.
Mr. Basu, unmute your system.
System কাজ করছে না, তো কোথায় বঙ্গ?
8, my lord.
Yes.
Page 128, subject to correction, page 128.
128, okay.
What is this comparison? No, it is
না, এটা
governmental document.
15 তারিখে। November 30.
Are you not understanding what my sister judge has asked you?
132.
আরে একটা annex ছিল।
Yes, 132.
Kindly see the note, my lord. The promotion is given on an ad hoc basis shall be subject to outcome of the following and any other case before the CAT. Narottam Pandey pending before Calcutta High Court. Devesh Shankar, Sham Sundar, After finalization of seniority list, grade of inspector in terms of so and so through new DPC may be revised accordingly. This is an ad hoc promotion.
And this
Lordship, that is Honorable High
Harinder
Court
is also promoted.
promoted, my lord.
Harinder is also promoted.
No, my lord.
Yes.
Narottam
After
Pa-
this,
Everybody got, well, what happened?
Narottam Pandey,
has not been promoted, my lord.
So his name
He
is
has been superseded.
one minute, one
They are all juniors. They are all juniors, my lord.
Pandey has retired.
Just retired. Not on 2020. He has retired in April
2023.
this year.
All right, so 1 minute. Let us make ourselves clear. We will understand. First and foremost, this 2020 September.
It is a
1
it is a
minute.
promotion order.
1 minute. This promotion order, as your learned friend pointed out,
Lordship.
is an ad hoc promotion
Hmm.
subject to a review after these court cases are disposed of. Right? Now,
Lordship.
1 minute. Let us make ourselves clear so that you can address us. We passed an order saying that November 30, 2015 list will remain state till the original application is disposed of. Right? Now, original application has been heard. Judgment is awaited. That is one point. So your fate and that list depends on what happens in the original application. According to you, during the pendency of the original application, they have uploaded another chart or a list of promotion where your name is not there. So, according to you, publication of a fresh promotion list pending that OA is a violation because a similar challenge is already pending in the tribunal and the High Court had stayed the list which had been published earlier. According to you, that list and this list, there is not much difference. But the one thing is that a finalization is subject to the court cases. And secondly, your client has already retired. So if in the OA, your client is successful today, the best option is he will get a notional benefit of money. Can your client stop promotion of others?
Lordship.
This is what you have to answer.
Lordship.
No, my lord.
Things are
My
there.
lord, certainly not, which your lordship is fallen from my lords, my lord. I request your lordship, my lord, to kindly take pain to turn page, my lord, 82 of the contempt application. Only 2 paragraphs, my lord, in the notice. If it appeals to my lord's conscience, that, my lord, that is exactly what we have said. I said, my lord, that before my right is crystallized, by virtue of the High Court's order dated 24/17/2018, my lord, the authority has, my lord, sought to stultify, my lord, the entire process. For the simple reason, my lord, I request your lordship, my lord, I will read for your lordships only 2 or 3 paragraphs. It is a notice communicated on behalf of my client to, my lord, the authority. Only, my lord, paragraph 2, page 82, 2, 3, and 4. That in the event of issuance of office order dated 19th March 2020 inter alia seeking VC or IC clearance for ensuing DPC for promotion to the grade of superintendent, a notice has been served on 23rd June 2018, in para 11 of which it has been stated that any promotion to the direct recruit appointee of 2005 and subsequent year till exhaustion of 2003 batch of promotees in according to promotional birth is made, it shall be deemed that such promotion is made from the band seniority list of 2015 because of the fact that those direct recruit appointees have been placed en bloc below 2003 batch of promotees in 2010 and 2008 seniority list of inspector. And it has been requested in the said notice dated 23rd March, June 2018 for not to take any steps that would be violative of Honorable High Court's order dated 24th July 2018, which can invite proceeding under contempt of Court Act 71. That a further notice dated 28th August 2020 has been served, inter alia requesting the concerned official respondents from publication or preparation of seniority list of inspectors, failing which appropriate legal proceeding would be initiated before the Honorable High Court. A copy whereof is annexed hereto for a reference. That surprisingly captioned reference has been published in CBSE website on 2nd September 2020 that stands infructuous or meaningless for all legal purposes and unprecedented, as well as there is no provision in DPC rules for publishing eligibility list post VCIC clearance, which falls under the jurisdiction of the DPC only. Although it has been described as list of eligible candidates in the grade of inspector to be considered for promotion to the grade of superintendent, the same not being done or described as a seniority list and cannot be published from Howrah Commissionerate, which can only be published from Kolkata North Commissionerate, being the cadre controlling authority in respect of the superintendent grade. And for that matter, Milord, that is what we have said. Now, Milord, I said your lordship wanted to know whether Milord, unless and until Milord the way Milord stand disposed of, Milord the way I cannot prevent others from being promoted. But at the same time, Milord, my right over the Milord juniors that has been disturbed, Milord. Milord,
No,
this is
how,
the
Mr.
question.
Masood, how is it being disturbed? Because today they have said this promotion, which they have given, is subject to result of the litigation. Your name, your matter is number 1 in that list of litigations. Today, if you are successful in the OA, the best order that you can get is a notional promotion, and your pensionary benefits will be calculated by giving you that advantage. Right.
Milord,
So why will this ad hoc promotion continue?
Because Milord, 24 July 2018, your lordship just now, Milord, possibly if I have correctly understood your lordship's mind, Milord, your lordship said that till the disposal of the OA. Now, Milord, there must be a logical end, Milord, to this OA. Before it is crystallized, before I might lose, Milord, in the way. But the question is, before the High Court is very certain, while passing its order, Milord said, Milord, till the disposal. The question is, the proceeding must reach its logical end. And before that, Milord,
we are here with willful and deliberate violation.
Milord, deliberate, Milord, Milord.
You brought it to their notice. They have said, we are making the seniority and promotion list subject to on an ad hoc basis. It will be reviewed after the litigations are over. That is their stand. They cannot.
I think that's absolutely right, Milord. I tell your lordship, I would take my lord 5 minutes. Only, Milord, 5 minutes. I'm extremely grateful for your lordship's patience, Milord. Only, Milord, 2 minutes. First of all, Milord, 2015 list was published, Milord, based on a memorandum of DOPTs, Milord 3/2008, which was based on a judgment passed by the Milord NR Parmar's case, which was overruled subsequently by the Supreme Court. Now, Milord, this list, seniority list, was published in 2015, Milord, in violation of the Supreme.
Overruled with the specific reservations that this overruling judgment would be prospective in nature.
Yes.
It was not given a retrospective in nature.
Absolutely. Absolutely. But the challenge subsequently thrown by the department in the High Court, Milord, that was entertained by the High Court. And thereafter, Milord, when the subsequent list was published, when we, Milord, carried out the proceeding in the High Court, Milord, we obtained, Milord, 24 July 2018 order. So, Milord, the 2018 order clearly says, Milord, I need not read for my lords, Milord, which clearly bars the authority from proceeding with the matter till, Milord, the original
Mr.
application.
Let us ascertain one thing, Mr. Lahiri. This was it finalized?
No. My lord will kindly take.
Look at the order. The promotion is given
Milord,
on a ad hoc basis. 1 minute, Mr. Basu, just
Milord,
hear. And 1 minute, and shall be subject to the final outcome of the following cases or any other case pending in High Courts, CAT, etc. Name of 6 are there. Anything else added to that? They are all going to abide by that. After finalization of the seniority list in the grade of inspector in terms of the DOPT CBIC legal instructions through review DPC, this promotion order may be revised accordingly. So what has happened to this promotion order now? Today, as of date, what is the situation?
We are waiting for the outcome of the OA.
Milord, where is that statement? Where is that statement?
We will record it and
Mr. Basu, the statement in the court, and they have now filed affidavit today.
May I, Milord, Kindly give me, my lord, 1 day time. I'm going to, my lord, because otherwise, my lord, I'm handling, there is a disturbance.
No, copy has been sent upon.
Yes, they have filed a reply also.
So why you say you were handicapped?
Reply also.
My lord, only I am saying, my lord, that what Mr. because the order dated at, my lord, page 41, my lord, your lordship said there let there be a stay on order of stay of operation of further operation of the memorandum, my lord, which was issued on November 30, 2050 till the disposal of the above original application. Now, my lord, we are given to understand that affidavits have been, my lord, we request the tribunal is yet to. My lord,
This is not.
this, my lord, this
Reply.
way, my lord, subject to correction, my lord, awaiting disposal. So, my lord, unless and until it comes to a logical end, my lord, any further steps by
Basu, under the service jurisprudence, Mr. Basu, under the service jurisprudence, the order was passed staying that particular gradation list. Now they say that there are many persons who are awaiting a promotion, and there is a promotional post also which should remain vacant for all time to come because the litigation has not come. They say to clear this impasse and the difficulties which the administration is facing, they are promoting certain peoples on an ad hoc basis, which will not create a vested right in them so far as the promotional post is concerned. That is what they say. Now it's an outcome. Suppose the outcome is that what you say is wrong. The tribunal has dismissed your application. What would happen? Who will compensate this particular entire 5 years or 7 years which was taken and consumed for these purposes? Who will? If you come with the thumping victory and then say they are open, they have said that we will immediately revise it. And if somebody who has been now promoted was not entitled to be promoted, he will be demoted. He will come back. This is difficulty. And remember, you have said that your lordship knows better than you.
That is always.
Remember.
Lordship, may I be permitted 1 point, my lord?
Who will argue, your senior or you? Tell me. That is
allow him, Millard, kindly allow him.
Either chose. Either you argue or he argues.
No, Millard, let him say, Millard.
No, definitely. Then we will not hear you.
No, kindly, I'm not making any submission.
Lordship, on 24th July 2018, 2 specific directions were there. That pending writ petition, one WBCT 81 was pending before Honorable High Court Calcutta, where there was stay. There was stay order issued by on 28 July 2014. Till such time, no seniority list could be published. If seniority list could be published, then that would be an academic issue. For that, my lord, only
Suppose there is no seniority list published. Suppose there is no seniority list
that
published.
2010 seniority list was there.
Hypothetical case, no seniority list published. But certain peoples have been given a promotion. It will be in violation of the statutory provisions. That's the only thing. Does it tantamount to a contempt?
Lordship,
Asking you.
Lordship, 2010 seniority list was operational. Since there was stay order.
People retired after that. That is why there was a 3-year gap. That is why they had to give that promotion.
My
You have
lord,
to understand that if people seniority, then they retire. So there is a gap.
Lordship,
In any case, there is no willful violation.
Lordship, no, Lordship, may I be permitted?
What do you expect the decision of the OA?
Arguments complete, reserved for judgment.
When?
I do not know, my lord.
When was it reserved?
To 1 month back. A month back.
Lordship, I am pleading there. In Lordship,
All right, we are keeping it in December. Come back.
My lord, one more thing, my lord.
Yes.
The list at page 44, 45, my lord, will see page 41, Narottam Pandey's name appear.
this is eligibility list.
This is eligibility list.
No, my lord, this is in fact it is seniority list. And board treated it as misconduct, my lord. Board subsequently made this position about it a misconduct. That is alleged complaint number 1 and 2.
1 and 2 get edit করে
1 and 2, my lord, he treated as misconduct. That commission order. And explanation was called for.
My lord keeps it, by the time order will come, my lord, everything.
Yes, take down.
No.
The alleged contempt numbers, the names of the alleged contempt numbers
3, 4, 5.
1 and 2 be expunged from the array of contemners. The name of so and so and so, so নামগুলো দিয়ে দিও.
3, 4 and 5.
The contempt proceedings will
No, they filed the opposition.
continue against the others.
acha.
Alleged contempt numbers 3, 4 and 5 have filed their affidavit in opposition. Replies have also been
Whereas the
filed.
present incumbents have filed because all of them were named or have retired.
The present incumbents to the post of the alleged contemners numbers 3, 4 and 5 have filed their respective affidavits. Reply to the same have also been filed. A supplementary affidavit filed by the applicant is taken on record. Let this matter appear in the second week of December,
We awaiting judgment.
awaiting the decision of the CAT, Central Administrative Tribunal. হ্যাঁ একটু দেখিয়ে দিও, ওগুলো একটু পাঠিয়ে দিও আমার কাছে, দেখে নিই। হ্যাঁ আচ্ছা, ওখানটা একটা লাইন একটু অ্যাড করে দিন। In the course of hearing of this contempt application, we have been informed that the original application which is pending pursuant to the order, যেটা contempted order, যেটা of this court, the original application has been heard and reserved for judgment.
On 38/2023 it was last time.
Reserved for judgment on 30th of August 2023.
ওটা লিখে দিন, reserved for judgment on 30th of August 2023. We deem it prudent to wait for the said judge for the decision before progressing further with the contempt application. Let this matter appear on the second week. Yes, next.
ছেড়ে দাও, রিভিউ তো আসছে না। Then appears dismiss. Good.
And appears in support of the application, dismiss.